Mr. Thathiah, if you would, give us your opening statement.
Sure, howdy, my name is Melvin Thathiah. Is that better? There we go. My name is Melvin Thathiah. I'm running for the 380th District Court. I'm a 15-year attorney. I've been practicing in family, criminal, and civil law for the last 4 years when I'm running my own firm. I grew up here in Texas after immigrating legally from South Africa, which is super important to me. My parents gave up everything that they had to be in this country and celebrate democracy and the freedoms that we have here in this country. So that's who I'm. Basically, your average kid grew up in Mesquite, Texas, went to Texas A&M University, met my lovely wife back there in the back there, and she was. I tricked her into staying with me for the last 20 years. We have 2 great kids, and we go to the Heights Baptist Church. A little about me as far as professionally speaking, I've also got some, I serve on the board for LifePath Systems, which is it used to be Collin County MHMR. They don't use that name anymore. So I serve on that board as well as a board for Brave Like Ellie Grace, which is an organization that we started to help give care packages to parents who learned about their children with cancers, mostly brain cancer. So those are a little bit about me and why me running for this bench, and I'm excited to answer some questions from you guys.
Good evening. My name is Ben Smith. I am the presiding judge of the 380th District Court. I've been the presiding judge since August of 2012, so almost exactly 7.5 years. Serving on that bench has been both the greatest honor and the greatest challenge that God's ever presented me with. It is a tough job, it is an important job, and it does extremely serious work. I believe in the rule of law. I do not believe in the rule of Ben Smith or any other person in a robe. I believe that every judge is obligated to receive evidence, apply the law as it's written, and to treat every litigant and attorney and everyone else who's participating with respect, dignity, and courtesy. I believe that I have done that. I am endorsed by the Collin County Conservative Republicans, Patriot Texas, and also every law enforcement association that has endorsed in the primary. My opponent does not have relevant experience for this type of bench. This court hears a majority of felony criminal cases. My opponent is not qualified to be appointed to represent an individual in a felony case. He applied in 2016 and was rejected by the district judges. He can't represent someone in the type of case that he would hear as a judge. He has also never tried a felony case to a jury in a district court. The first time that you preside over a felony in district court is not the time for you to be the judge in that case. I believe that relevant experience is important. I have it, my opponent does not, and I would love to have your support. Time is limited with these things, but I'm perfectly happy to speak to anybody if you would like to talk about my experience, my qualifications,
Thank you.
And my job so far. Thank you.
And with that, we're going to go to the first question. Mr. Smith, we'll start with you. I'm probably going to truncate these to make sure we're on time. Yes, I know. Question number 1. This is a general jurisdiction court, as you noted. As you understand it, state the current percentage breakdown of the court's caseload between criminal, civil, and family, as you currently see it, and your experience in handling these types in each particular field.
With the 2 new courts going online as of October 1, 2019, a civil district court and a family district court. After October 1, the allocation of cases in the 380th District Court and the other 6 general jurisdiction courts are approximately 70% criminal, and those are all felonies. So about 70% criminal felonies, 15% family, and 15% civil. Obviously, as the judge for the past 7.5 years, I have relevant experience in all of those cases because I'm the one that's been presiding over them. The civil cases can range from personal injury cases to complex business disputes to medical malpractice suits. The family cases are comprised of divorce suits, modification suits, suits for child support, also adoptions, original SAPSers where the parties were never married and they had a child together, and the criminal felonies ranging from burglary all the way up to capital murder. This is a court where the death penalty is a potential punishment. I have tried all of these cases both as a prosecutor and as a judge.
Thank you, Mr. Thathiah.
That was, you
Yeah,
you already
so
got the,
general jurisdiction court, state what your understanding of the breakdown between civil, criminal, and family, and what your experience is with each.
my understanding of those is that as a practicing criminal defense attorney, I have experience with criminal defense work at the misdemeanor level. When I did apply, I was very ambitious in my hopes of getting appointed to that particular wheel. I didn't actually get a letter from them or anything like that rejecting me, but I didn't get appointed to that wheel. But I guess the judge would know that because he was at those meetings. So now I've been practicing law for 15 years, and that was the initial part of applying for those wheels. I got appointed to the wheel for the misdemeanor courts because and that was with no experience on the misdemeanor wheel. So I've got experience in hearing and trying these kind of criminal cases. I've also got experience in civil litigation and family law litigation. And 8 years ago, when Judge Smith ran, he was not touting experience. He didn't say that experience mattered then when he was running against an attorney with more experience. I've been practicing law for 15 years, and I'm very capable of handling, listening to, and judiciating over cases regarding family law cases, which I have experience in, civil cases, as well as criminal cases.
Thank you. And then just a real quick parenthetical note. You noted I said Mr. Smith, not Judge. I did it on purpose. I count both of you as friends, but in the U.S. Senate, when they talk to other senators, they actually refer to them as Mr. I do it intentionally to be a level playing field. I want people to listen to you as an individual, to earn your vote based on your answer, not based on your current position. So, Mr. Thathiah, next question. Why are you more qualified for the job than your opponent?
I'm more qualified for this position because I've been practicing law. I also have experience as a visiting judge in the JP courts here in Collin County. That was an honor that was appointed by the Collin County Commissioners Court. I have heard cases. I've also spent 15 years practicing and dealing with high levels of litigation, high amounts and numbers, and this court right now is operating at as the least efficient court over the past, from at least 2014 to 2018, if you look at the total numbers. And so I feel like my experience in dealing with a law firm, when I was with a law firm that dealt with 2,000 cases at a time, 2,000 cases filed a month, I managed that caseload and helped make sure that those cases were litigated efficiently, and I think I can do the same here with this court and maybe make it a little more efficient than it is right now. I also feel that this court has got right now issues with the fact that litigants don't feel like they're getting an impartial trial, and I think that an important aspect of this court is that people, when they come into court on the most important day of their life, they need to feel like the judge is going to be following the rule of law, just the rule of law, impartial to no party, partial to no parties, so an impartial jurisprudence, as well as someone who is transparent in their decision making, so that all the parties involved know why the decisions are being made and so that they know that they've been heard.
Mr. Smith?
Well, the truth is that my opponent is patently unqualified for this position. He is patently unqualified. And I'm sorry, but sitting as a temporary justice of the peace on occasion does not make one a judge. And presenting yourself as a judge and wearing a black robe when you are not a judge is unethical. It is extremely unethical. My opponent is not a judge, and sitting as a justice of the peace, you are presiding over traffic tickets and Class C misdemeanors that are not punishable by even jail time. A justice of the peace does not even have to have a license to practice law. You cannot compare a justice of the peace, even if he were a justice of the peace, which he is not, to a district court judge. There is no comparison whatsoever. And I've heard this lie about my court not being efficient, one time too many. I have the data. Anybody that wants to see the data and see the truth, just come and see me. I'll show you the data. Because that representation is another unethical lie perpetrated by this campaign, by my opponent's campaign.
I believe we're on to the next question. I'm going to skip one. We're going to go to the next one. So, help me, gentlemen. Is it Mr. Smith that answered the next one? Yes. Please describe, so what we do is intentionally get into the weeds of some things of the job. You might not understand the question, but they should, because they're running to be judged. Please describe your philosophy regarding paying attorneys to represent indigent citizens in criminal and CPS cases, including your view about flat fee versus hour fee plans.
Well, I know a lot about this subject because I was the local administrative district judge for the previous 2 years, and I wrote the new indigent defense plan, as well as the new fee schedule, which returned Collin County to a fixed rate flat fee plan. There is some data that supports a fixed rate flat fee plan provides adequate representation of criminal defendants in a cost-efficient manner, and I believe that's why it won the support of the district judges to return to a fixed rate plan. It's a difficult balancing act. It always is, because each individual who is accused has a constitutional right to effective representation. And if that person meets standards of indigence, they have the right to have counsel appointed to represent them. And when counsel is appointed to represent them, they must be fairly compensated. And so those are really difficult issues when you're balancing those obligations and those constitutional rights to fair trial and competent representation with also the judge's obligations to be good stewards of taxpayer dollars. So that's always kind of a difficult balance. I believe that the district judges currently on the courts have done an outstanding job of balancing those two factors.
And I mean, if it's a tedious question, I can repeat it, Mr. Thathiah.
Sure.
Yes, please describe your philosophy regarding paying attorneys to represent indigent citizens in criminal and CPS cases, including your view about flat fee versus hour fee plans.
I think that we, as a community, we don't have a public defender system, so we have to pay attorneys who apply for these wheels to get on them and then get paid for the work that they did on the case. You guys may or may not be familiar with the story about the attorney that had billed about $500,000 in a year against the district's courts in Collin County. I feel like to avoid that kind of problem, I think we should move towards a system of just flat fee payments for and having it be something that does not go above and into hourly rates for things that are too there's no discretion, like how high or low fees can be charged and that sort of thing. And I think that what needs to happen is we move maybe towards something of a flat fee rate to control how much we're spending on appointing counsel. And I think the attorneys that have a heart for that and are truly trying to be there to represent clients will stay on that wheel and do the work in that environment, rather than trying to get rich off the wheel, or something of that nature. So I think that controlling that is an important
Thank you, and I think it's to you, Mr. Thathiah. Explain your philosophy of how a district court judge, the role you're seeking, should determine whether requests for bench warrants and trial continuances are granted. What goes through your mind of how you determine those things? Bench warrants and trial continuances are granted.
So, I think when we're dealing with bench warrants and trying to get a person in front of the court, you have to. Can you ask the question one more time?
Yeah. How do you determine
whether
requests for bench warrants and trial continuances are granted?
Okay. I think I would consider the efficiency of which and how much the court is spending on keeping a person in jail somewhere or moving them over, and how long they've been that haven't had a case sitting in the court system, and that sort of thing. I think that you need to consider those things when you're trying to get when you're deciding whether or not you're going to bring a defendant over from another county's prison or something like that, or holding. And I think with the trial continuances, I think you really do have to press the issue. And there's a great judge in here actually who started asking questions more about passes rather than just allowing people to continue cases on and on, attorneys to continue to move cases down the docket. I think he's started to ask the question and make it a little more to test whether or not those continuances or if cases are being worked efficiently, so that they're not staying on the county's docket for indefinite periods of time.
For anyone who doesn't know, a bench warrant becomes necessary if a person has a pending felony case in a district court, and that person happens to be incarcerated in another county's jail or in state prison or in a prison or jail from another state. Well, then that kind of gets into governor's warrants as well, which are similar but different. I think that certainly a bench warrant is necessary to bring the defendant to Collin County to resolve the case that's before that court, but the decision has to be made again with a mindfulness about the expenses of housing that person in Collin County at Collin County's expense. So to make it more efficient and to, I think, reduce the cost to Collin County to the largest extent possible, you wait until the case is set for disposition. So if somebody gets indicted and I issue a bench warrant, or I sign a bench warrant to bring somebody over from TDC or from Dallas County Jail, or wherever the case may be, he's going to come or she's going to come and sit in the county jail for months, if not longer, awaiting resolution to their case. That entire time, that inmate is an expense of Collin County as opposed to the county that we're bringing the person over from. So it makes more sense and it's more efficient to wait and bench warrant after the case gets set for trial to minimize the amount of time that person is in Collin County before they go on their way. All judges hate continuances, but continuances are sometimes necessary. And there are a host of reasons why a continuance might be necessary. It's not, continuances are not something that you can just blanket say they're never appropriate or they're always appropriate. Cases are very fact specific. In one case you might have an attorney who's extremely ill or just had surgery. You might have another case where the DA is having a hard time finding their victim because the victim has disappeared.
And with that, Mr. Smith, I'm sorry, I have to cut you off. You can respond more in your wrap up. I have other questions. We don't have time to do it. This is what we're going to do. We're going to go into our lightning round, and you have 1.5 minutes for a closing statement. We tried to pack in a lot tonight. So, lightning round, very straightforward. You've heard these before. Let's start with Mr. Thathiah. For each one, go to Mr. Smith. Have you ever been arrested or charged with a felony?
No.
No.
Have you committed a felony or been convicted of committing a felony?
No.
No.
You know, that first one's just see if they're being honest. If they didn't get caught, but they, yeah. Okay. Number 3, have you ever been disciplined, reprimanded, or cited for breach of ethics or for unprofessional conduct by a court, administrative agency, bar association, disciplinary or grievance committee? I can repeat it, but basically you know the intent of this.
Ask the question.
Yep. Have you ever been disciplined, reprimanded, or cited for breach of ethics or unprofessional conduct by a court, administrative agency, bar association, disciplinary or grievance committee, or other professional group?
No.
No.
Number 4, have you voted for a Democrat candidate at any level in the last 10 years?
No.
No.
Have you failed to vote in any primary or general election in the last 10 years?
Yes.
I don't know. I have my voting record if anyone wants
You
to see
go,
it.
you go
Judges-
explain. I will cut you off. You can go explain in your just yes or no or pass. I'm sorry, I'll have to do that. And then you explain in your closing statement.
No, I've not failed to vote.
Okay. Do you personally believe your opponent is fit to hold this elected position?
Yes.
No.
And a 1 or 2 word self-identifying? How would you self-identify politically? Republican, Democrat, Socialist?
Constitutional conservative.
I am a conservative Republican.
Okay. And with that, let's do closing statements. Did we start with you? Mr. Smith, would you like to do a minute and a half closing statement?
Well, first of all, my opponent is on record at a previous forum stating that he has been reprimanded, so I'm not really sure how that's not being contradicted here. I thought it was a pretty straightforward question. Listen, the reason that I have an opponent in this race is because an angry mob of people are unhappy with not receiving the political ruling that they wanted. Because I declined to hear a case. And they've managed to find some other unhappy litigants. I'm surprised that after 16,000 cases in 7.5 years, they haven't found more. Because I think they're still in the single digits. And this campaign isn't being run on substance. I tried it that way. And it wasn't working for my opponent. It's all about attack me. That's the entire campaign. In fact, they are so contemptuous of me being in this position that they recruited 6 lawyers that I know about to run against me, all of whom said no, and he's a good judge, and he didn't do anything wrong. Then on the last day before the end of the filing period, they find my opponent, who called me that day and said he had no plans to run against me, that he thought I was a good judge, and that I didn't do anything wrong. And this was after talking about, on the phone, talking about this Rosales case. And
That's the time.
Okay, so I said I haven't been disciplined because the discipline was, I did say in an open forum, it was actually a private it was not a reprimand. What had happened was, it was in that bar complaint, the committee found that there was no finding and that they needed to, that all I had to do was take a class and do in full disclosure, it was not a reprimand. It was just a class you have to take when you get a complaint or that sort of thing. And it's not something that would ever show up anywhere because it was a private one. So it was something that I told you out of honesty and transparency. So as far as me being qualified to be a judge in this court, I'm a 15-year attorney. I will, if there's something I don't know about, I will take the time to learn about it and make sure every judge that starts out in district court, they have you go to a baby judge school, is the kind of nickname for it, and you learn how to do you learn how to do the things that you don't know how to do and that sort of thing. Now, as far as I looked up records and things like that on what the numbers were for the court and that sort of thing, and the things from Collin County documents seem to state the things that I said. I'm not going to try to be
And I have to treat candidates fairly. I'll cut you off as well. Folks, let's give them a round of applause.